Hi, my name is Professor Dr.Debarati Halder, and in this session we are going to discuss about conceptualizing e-governance, the basic understandings under the Information Technology Act. The Information Technology Act 2000, amended in 2008, does not define the term electronic governance. One of the basic objectives of the IT Act 2000, amended in 2008, is facilitating the electronic governance. E-governance may necessarily include e-service delivery, retention of electronic record, generating e-records, and recognition of electronic records. Certain terms to be understood in the context of electronic governance are data. Section 2(o) defines data as a representation of information, knowledge, facts, concepts, or instructions which are being prepared or have been prepared in a formalized manner and is intended to be processed, is being processed, or has been processed in a computer system, or computer network, and may be in any form including computer printouts, magnetic or optical storage media, punched cards, punched tapes, or stored internally in the memory of the computer. The second term that we need to understand is electronic record. Section 2(t) defines electronic record as data, record, or data generated, image or sound stored, received, or sent in an electronic form, or microfilm or computer generated microfiche. Section 2(p) defines digital signature. It means authentication of any electronic record by a subscriber by means of an electronic method or procedure in accordance with the provisions of Section 3. Section 2(ta) defines electronic signature, which means authentication of any electronic record by a subscriber by means of the electronic technique specified in the second schedule and includes digital signature, which means this particular provision is inclusive of nature and electronic signature includes digital signature. Section 2(r) defines electronic form. It says electronic form with reference to information means any information generated, sent, received, or stored in media, magnetic, optical, computer memory, microfilm, computer generated microfiche, or similar device. Section 2(v) defines information. It says information includes data, message, text, images, sound, voice, codes, computer programs, software, and databases, or microfilm or computer generated microfiche. Now, we should understand about various segments of electronic governance under the Information Technology Act. The first segment would be about legal recognition of electronic records. This has been discussed under Section 4. It says, where any law provides that information or any other matter shall be in writing or in the typewritten or printed form, then, notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied if such information or matter is rendered or made available in an electronic form and accessible so as to be usable for a subsequent reference. Here we can see that two aspects have been addressed, that is, when it is made available in an electronic form, and the second aspect is it is actually accessible, that means it is retained and it should be usable for a subsequent reference. The next aspect of e-governance is legal recognition of electronic signature. Section 5 discusses about this and says, where any law provides that information or any other matter shall be authenticated by affixing the signature, or any document should be signed or bear the signature of any person, then, notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied if such information or matter is authenticated by means of digital signature affixed in such manner as may be prescribed by the central government. It also says signed with its grammatical variations and cognate expressions shall, with reference to a person, mean affixing of his handwritten signature or any mark on any document, and the expression signature shall be construed accordingly. Here we can see that digital signature has been mentioned, whereas the title says legal recognition of electronic signature. As we have seen in the earlier section, electronic signature and digital signature have been construed synonymously under the IT Act 2000, amended in 2008. The next aspect of electronic governance is use of electronic records and electronic signature in government and its agencies. This has been discussed broadly under Section 6. It says, where any law provides for the filing of any form, application, or any other document with any office, authority, body, or agency owned or controlled by the appropriate government in a particular manner, the issue or grant of any license, permit, sanction, or approval by whatever name called in a particular manner, the receipt or payment of money in a particular manner, such requirement shall be deemed to have been satisfied if such filing, issue, grant, receipt, or payment, as the case may be, is effected by means of such electronic form as may be prescribed by the appropriate government. Now, let us see some examples of electronic records and electronic signatures in government and its agencies. For example, the Aadhaar card or the Aadhaar document can be considered as an example of electronic records, and also electronic signatures, especially where it bears our signature. Again, C for e-filing of the income tax by Income Tax Department, Government of India. Even this can also be considered as a very good example of electronic record. The signature that we generally affix here is electronic signature, and this can be considered as a legal document. Again, it says the appropriate government may, for the purpose of subsection 1, by rules, prescribe the manner and format in which such electronic records shall be filed, created, or issued. The manner or method of payment of any fee or charges for filing, creation, or issue any electronic record under Clause A. The next aspect regarding e-governance includes delivery of services by service provider. This has been discussed under section 6A. It says service provider so authorized includes any individual, private agency, private company, partnership firm, sole proprietor firm, or any such other body or agency which has been granted permission by the appropriate government to offer services through electronic means in accordance with the policy governing such service sector. We can see here that the government department concerned may not be the direct agency for providing the service. There can be some other agencies which are commissioned by the government for effective delivery of the services. The section further says the appropriate government may, for the purposes of this chapter and for efficient delivery of services to the public through the electronic means, authorize by order any service provider to set up, maintain, and upgrade the computerized facilities and perform such other services as it may specify by notification on the official Gazette. Further, it says the appropriate government may also authorize any service provider authorized under subsection 1 to collect, retain, and appropriate service charges as may be prescribed by the appropriate government for the purpose of providing such services from the person availing such services. As we can understand, the agency which is acting as the service provider as per the order of the appropriate government is duty bound for data protection, upgradation of the electronic platform, and also the process how the service can be provided. Also, it can create certain mechanisms for collecting, retaining, and appropriating service charges. Subsection 3 says, subject to the provisions of subsection 2, the appropriate government may authorize the service providers to collect, retain, and appropriate service charges under this section, notwithstanding the fact that there is no express provision under the Act, rule, regulation, or notification under which the service is provided to collect, retain, and appropriate e-service charges by the service providers. Further, subsection 4 says The appropriate government shall, by notification in the official Gazette, specify the scale of service charges which may be charged and collected by the service providers under this section, provided that the appropriate government may specify different scale of service charges for different types of services, which means that the service providers, which may be private organizations, cannot ask for exorbitant service charges. There should be some ceilings for such service charges, which is generally settled by the appropriate government. The other aspect of e-governance is the retention of electronic records. This is discussed under Section 7. It says, where any law provides that documents, records, or information shall be retained for any specific period, then that requirement shall be deemed to have been satisfied if such documents, records, or information are retained in the electronic form. It further says the information contained therein remains accessible so as to be usable for a subsequent reference, which means retention of electronic records must be made for subsequent reference and it must be accessible. Subclause B says the electronic record is retained in the format in which it was originally generated, sent, or received, or in a format which can be demonstrated to represent accurately the information originally generated, sent, or received. This has been created for a purpose to protect the confidentiality of the data. Subsection C or subclause C says the details which will facilitate the identification of the origin, destination, data, date, and time of dispatch or receipt of such electronic record are available in the electronic record. Now, let us discuss about certain exceptions for this provision. This clause does not apply to any information which is automatically generated solely for the purpose of enabling an electronic record to be dispatched or received. The second exception is, nothing in this section shall apply to any law that expressly provides for the retention of documents, records, or information in the form of electronic records. The next aspect of electronic governance is audit of documents, etc. in electronic form. This has been discussed under Section 7A. It says, where in any law for the time being in force, there is a provision for audit of documents, records, or information. That provision shall also be applicable for audit of documents, records, or information processed and maintained in electronic form. We must understand that several cybersecurity experts have stated that auditing of documents is extremely important to maintain the confidentiality of the data and also to prevent cyber terrorism or infringement of the data privacy, especially in order to protect the integrity and also informations which are necessary for national integration as also national security. Section 8 discusses about publication of rules, regulations, etc. in electronic Gazette. It says, where any law provides that any rule, regulation, order, bylaw, notification, or any other matter shall be published in the official gazette, then such requirement shall be deemed to have been satisfied if such rule, regulation, order, bylaw, notification, or any other matter is published in the official gazette or electronic gazette. However, there is a small twist here. The date of publication of any rule, regulation, order, bylaw, notification, or any other matters published in the official gazette or electronic gazette shall be deemed to be the date of the gazette which was first published in any form, which means that the date on which the rule was published will be the date on which the gazette was first published in any form. Section 9 further discusses that nothing contained in sections 6, 7 and 8 shall confer a right upon any person to insist that any ministry or department of the central government or the state government or any authority or body established by or under any law or controlled or funded by the central or state government should accept, issue, create, retain, or preserve any document in the form of electronic records or effect any monetary transaction in the electronic form. This particular provision has been created keeping in mind that in India there are several persons who may not be digitally literate. Section 10 speaks about power to make rules. It says the central government may, for the purpose of this act, by rules prescribe the type of electronic signature, the manner and format in which the electronic signature shall be affixed, the manner or procedure which facilitates identification of the person affixing the electronic signature, control processes and procedures to ensure adequate integrity, security and confidentiality of electronic records of payments, and any other matter which is necessary to give legal effect to electronic signature. Now, let us discuss a very important aspect of e-governance, that is, electronic governance and validity of contracts formed through electronic means. This has been discussed under Section 10A. It says, where in a contract formation, the communication of proposals, the acceptance of proposals, the revocation of proposals, and acceptance, as the case may be, are expressed in electronic form or by means of an electronic record, such contract shall not be deemed to be unenforceable solely on the ground that such electronic form or means was used for that purpose. Now, we will discuss about the governance of electronic records for attribution, acknowledgement, and time and place for dispatch. This is also a discussion that we will see under the heading e-commerce. Electronic records necessarily needs attribution, which is discussed under section 11, acknowledgement of receipt, which is discussed under section 12, and also very important is time and place for dispatch, which is discussed under section 13. Thank you.